Less than 36 hours left for the 1993 Bombay blast convict Yakub Memon scheduled execution. But the big breaking news coming in at the moment is that with the Supreme Court bench divided over whether or not to go ahead with the hanging as scheduled after a split decision, the petition has been referred to a larger bench that will take up the convict's petition tomorrow. That's the story that we are getting, and at the moment, as I said, the Supreme Court will begin the hearing, as you can see in your flashes, a three-member bench at 10:30 a.m. tomorrow morning. This is after there was a split verdict in that case, in the Yakub Memon case. Joining me now at the moment, Prashant Bhushan, advocate of the Supreme Court, is joining me. Nitin Pradhan, senior criminal lawyer from Mumbai, to try and understand what this means. Prashant Bhushan, what does this now mean? The very fact that the Supreme Court has gone ahead and constituted a larger bench to hear the Yakub Memon plea, because 30th July or day after tomorrow is the scheduled day of execution.
Well, it means that because there was a split opinion among the two judges who heard this matter today, therefore a fresh three-judge bench has been constituted to hear this case, and in case the hearing remains inconclusive till the time that the hanging is scheduled, I am sure that they will stay the execution till such time that they are in a position to decide the matter. The issues, I mean, the split opinion among the two judges was essentially on the basis, Justice Kurian Joseph felt that firstly, the curative petition of Yakub Memon should have been heard by a bench which included the judges who heard the review petition, because the original judges who had heard the main appeal of Yakub Memon, they had retired, and therefore the rule for curative petition is that it is heard by the original judges who have heard the matter plus the senior three judges of the Supreme Court. So it should have been heard by all those three judges who had heard the review petition.
So is it purely therefore on procedural grounds? Is it purely on procedural grounds that therefore tomorrow the three-judge bench will now decide, because the same bench did not hear the curative petition that had heard the original review petition A, and B, because the curative petition, the death warrant was issued by the Maharashtra government even before Yakub Memon had brought his curative petition to the court. Will they hear both these procedural grounds, or is it on substantive issues whether Yakub should get the death penalty or not that the court will hear?
No, there is a substantive issue also, which is that there is a mercy petition which has been filed after the dismissal of the curative petition, after the judicial process was over, until those mercy petitions are decided. Because see, there is a new fact which has come into play, which apparently was neither brought to the notice of the trial court nor the appellate courts earlier, nor was it brought up really before the President, which is the mitigative grounds cited in an article by Mr. Raman, who was a senior intelligence officer who was involved in bringing Yakub Memon back to India, as well as who followed the subsequent developments in the case, and who has pointed out that Yakub Memon was brought willingly to India, and he cooperated fully with the investigative agency in order to help them get more evidence against Pakistan, etc. So this was a fact which was not really brought before the courts or before the President or the Governor, who earlier considered some.
So you're saying the three-judge bench will also could look at the substantive issues, the fact that certain what you believe are material facts were not brought before the court. It is not purely procedural. Nitin Pradhan, the other view which is being expressed is that this is purely an attempt by Yakub Memon's lawyers to delay the execution, to buy some time. Are you of that view, that Yakub Memon is clutching at straws and trying to buy time at the moment?
Frankly speaking, this is the last chance for him, and this is the only chance for him. Once the sentence is executed, what is the meaning in deciding whether there is a curative petition was pending, whether there was any legality, illegality while passing the order of death sentence. So this is the last chance for him. Let him have
do you
that
believe
chance.
he deserves it or not?
Let the
If
Supreme Court
material
decide
evidence, Mr. Pradhan, if material evidence
question
that
is-
Yakub
no,
Memon was fully cooperating with the agencies, that he was brought back by the agencies and he shared information including about Dawood and Tiger Memon's whereabouts, if this information was not provided to the courts, should this not be a ground for rehearing the case, for reviewing the case in your view?
This could be, but frankly speaking, this is the deficiency in service by his lawyers there. During the trial, why this aspect has not been agitated, why this aspect has not been brought before the court by leading
But why should a man die?
Evidence which is
For the failure of lawyers, should a man die?
no doubt about it, no doubt about no, that is what I am saying. Therefore, this particular aspect will have to be taken into account by the Supreme Court while deciding the issues now, because curative petition is basically for very limited purpose and for within the limited sphere. It can be decided, but a legality and the propriety, that also should be included while deciding the curative petitions, because that is the only chance for accused facing a capital punishment. So
can I just get a final? Can I get just a final word from you, Prashant Bhushan? Does this show the strength of the Indian judicial system or the weakness of the Indian judicial system? The fact that 36 hours before Yakub is to be given the death sentence, we now have a split verdict which has forced the Chief Justice to bring in a fresh 3-judge bench.
Well, it shows both the strength and the weakness of the Indian judicial system. It shows that sometimes through the Indian judicial system there can be miscarriage of justice, sometimes even very serious miscarriages of justice. But it also shows that the Indian judicial system can rise to the occasion and can cut through such procedural issues or such technical issues and get to the substantive issue in the matter, which is really the substantive issue in this matter is whether in the light of such mitigative circumstances which have been cited by Mr. Raman in his article or in the note that he wrote, whether in these circumstances does he deserve capital punishment, does he need to be sent to the gallows, what kind of message is this going to send? Quite apart from this whole debate about whether capital punishment should remain in the statute books of this country or not, which is a very live debate these days.
Let's leave it there. Let's leave it there. We will wait to see. We don't want to discuss the substantive issues at the moment. I'm going to leave that to the merits of the case to be decided by the Supreme Court tomorrow. But the very fact that a 3-judge bench has now been constituted clearly shows that the Supreme Court is treating this case with renewed seriousness. Prashant Bhushan, Nitin Pradhan, appreciate your joining me on the news today at 9.